Well, ladies and gentlemen, welcome to this, the third of the 4 readers' lectures this year. And a particular welcome to those here and also online, but above all to our guest speaker, Michael Beloff, King's Counsel. I find that a difficult thing to say because to me and so many others, he is, as the title of his recent book has it, MBQC, and that's how he will always be to me. We are delighted that he has come to speak to us today. My original idea, consistent with the theme, the sort of broad theme of the lectures this year, which is the relationship between the executive and the courts, was that he might speak from the viewpoint of an advocate, indeed a preeminent advocate in constitutional law, following on the perspective from Lord Butler as former Cabinet Secretary, Professor Endicott as academic from All Souls, and from Dominic Grieve, who will be speaking later this year. We talked about that and talked more. And the more we spoke, I realized that he would rather like to speak about something from another part of his lifetime and his practice. He has been preeminent in so many areas. I mentioned constitutional law, but in particular, in recent times, sports law. When I started at the bar, I suppose the sport and the law had some occasional collision, but it wasn't regarded as a law topic of itself. There were 1 or 2 hardy souls. I think a book on sports law was produced, but really through Michael Beloff, who has been described as the godfather of sports law, it has gone on to take a life of its own. I gather from reading his wonderful book that a lot of his interest was fueled by his own enjoyment of athletics, and not least from winning the 100 yards at school just a few years ago.
That dates me.
And then, so as athlete, as advocate, as author of one of the leading book on sports law, and as arbitrator in a whole series of arbitration bodies. I've been trying to work out all the acronyms in recent times as I read the book, but notably the CAS, the Court of Arbitration for Sport. He has been preeminent in that field, and he is speaking tonight on the topic of law, justice, and rules in the world of sport. As I say, it's a delight that he is with us tonight. Thank you in particular for having, whether it's by way of sprint from Middle Temple and Blackstone or by cross-country run from Gray's Inn, come across to Inner Temple. Michael Beloff.
Good evening. Sport matters. It matters to those who play, whether for pleasure or profit. It matters to those who follow matches, whether live or on screen or in print. Sport can arouse profound emotions, sometimes joyful, sometimes sad. Who can forget the Wimbledon men's singles final, Carlos Alcaraz defeating Novak Djokovic, a sporting metaphor for J.F. Kennedy's famous line, "A torch has passed to a new generation." Who can forget the Seesaw Ashes series, English hopes rising until dashed by rain? Who can forget the Lionesses' journey to the World Cup final, England's hopes rising until dashed by Spain? Sport inspires loyalty, especially but not only in football, to club teams, even those without a single player from the city or town or area which gives the club its name. Sport is significant in terms of economics, representing 1% of the world economy, which equates to approximately $1 trillion of annual activity. Sport is significant in terms of politics, however much it is argued that it should not be. Consider the recurrent debate as to which national federations should be invited to send teams to the Quadrennial Olympics, with its current example of Russia, Belarus, and Paris 2024. And whether invited teams will accept an invitation. Recall, if you may, the United States boycott of Moscow in 1980. And sport is indeed significant enough to justify for the first time a lecture in this prestigious series focused on it. Now, my title, Law, Justice and Rules in the World of Sport, has survived the eagle-eyed scrutiny of the Bar Standards Board on the ground that my mandate is to provide education, not just, maybe not even, entertainment. My chief credentials for speaking to you on that chosen topic are these. I've been a member of the Court of Arbitration for Sport, which we will now call CAS. Thank you, Master Reader. The World Court of Sport, based in Lausanne, the Olympic City, for 25 years. And I've arbitrated for CAS at 5 Summer Olympic Games. Alas, as now an octogenarian, I'm about to become the equivalent of what Lord Bridge, then senior law lord, compelled to retire on the grounds of age at a mere 75, described as statutorily senile. And of the 3 international sports whose ethic commission and disciplinary tribunals I have chaired, cricket, athletics, and skiing, I shall soon retain involvement only with the Ski Federation. So from now on, for me, it's downhill. None of these activities, I must confess, owe anything to any talent on track, pitch, or slope. I console myself that sports law offers its opportunities to the sedentary as well as to the sporting. And I shall plead guilty in advance, and as those who know me a serial offender, to using examples from my own casebook as an arbitrator as well as an advocate to illustrate some of the general themes I shall explore this evening with you. But at least I shall try to restrain myself from immodestly telling you, unless of course I'm asked, which those cases were. Now, English law has never provided a comprehensive definition of sport, and as in so many areas of the law, context is all important. Recognition in law as a sport has implications for matters such as lottery funding and value-added tax. In a case taken to Luxembourg by the English Bridge Union, which claimed a VAT exemption on the basis that bridge was a sport, the European Court of Justice denied their claim. It said, the concept of sport appearing in that provision is limited to activities satisfying the ordinary meaning of the term sport, characterized by a not negligible physical element. And there's no reason to believe that Brexit has altered the position from the perspective of English law, since the High Court has adopted a similar approach in considering the meaning of sport in the Royal Charter of Sport England. In short, all sports are games, but not all games or pastimes, another activity which is found in statute, are in law sports, at any rate, not for all purposes. Now, you may think that a negligible physical element is a necessary, but hardly a sufficient description of sport. To qualify sport as a physical activity must surely have rules which govern how it must be played. Such rules, a match's length, the weight of a discus, the width of a goalmouth, the type of footwear, are not compelled by the laws of physics or by some moral code. Subject always to the need to comply with the law of the land, they are constantly under review by sports governing bodies, which are influenced by such considerations as the safety of participants, see the tackling rules in rugby union, the enjoyment of spectators, see the tie break in tennis, which was to prevent the lengthy becoming the interminable, see the demands of television, which influences the location of events, kickoff times, and even playing seasons, rugby league being converted from a winter to a summer sport, or broadening participation, an exotic example being the admission of mules to dressage competitions traditionally reserved for horses. The rules defined how the sport must be played. The rules define how victory is achieved. The rules define who should adjudicate whether the rules themselves have been complied with and who can enforce compliance. The rules, be they old or be they new, would be meaningless if they could not be enforced. And the rules define who can administer a sanction for breach of the rules and what kind of sanction they can administer. Now, it is a fundamental element in sports law, the so-called field of play rule, that referees or umpires or other officials exercise of their judgment or discretion in good faith, nowadays aided, some might say impeded in football by VAR, in sports such as rugby, cricket, and tennis by equivalent technology, is beyond challenge, otherwise than insofar as the rules of the sport themselves provide. So prima facie, it creates a sphere of autonomy into which even appellate sports tribunals, let alone courts, must not trespass. There are various justifications for this rule: the fear of constant interruption to the course of play by lawyers, the problems of rewriting a result after the event, the need to strengthen the match official's hand, and an arbitrator's or judge's lack of expertise in the technical side of sport. The controversy over the denial of a goal to Liverpool in their match against Spurs on Saturday, the assistant referee ruled the goal offside, though according to television recordings, it was clearly onside, and there was no VAR intervention to correct what the referee's official body has since acknowledged to be, and I quote, a significant human error, promising at the same time a full review as to what went wrong. This will be scant consolation to Liverpool, since the result will survive forever: Spurs 2, Liverpool 1. But that is an example of the force of the field of play rule. Let me tell you of a precedent. In Yang against Ham, a CAS panel had to decide after the Athens Olympics in 2004 whether to reallocate the medals in the men's gymnastics all-round final, where the silver medalist, a Korean, had also been the victim of what was an admitted error by the judges as to the grading in terms of its difficulty of his parallel bars exercise, the penultimate exercise of the 5, the grading being the point of departure for the evaluation of his performance. Now, you might think the answer obvious: uplift his score mathematically by applying the correct figure for the difficulty of the exercise, which would in that case have promoted him to the top of the podium. But on reflection, it was decided that this would bypass the field of play rule. And 2 citations from what was an elaborate award will explain the approach. First, any contract a player has made in entering into competition is that he or she should have the benefit of honest field of play decisions, not necessarily correct ones. And second, finality in this area is all important. Rough justice may be all that sport can tolerate. After all, how could one know if the Korean gymnast had, in consequence of any upward revision, gone into the last round of the 5 in the lead? He might have frozen. He might have been inspired. One can never know. I would add, if it consoles you, that sports tribunals may interfere if an official's field of play decision is tainted by fraud, by arbitrariness, or by corruption. In such circumstances, rare as they mercifully are, the match result in a team game will be set aside in favor of the victim of the referee's misconduct. Now, beyond the boundaries of the field of play rule, sporting disciplinary offences contrary to the relevant code are usually resolved by sport-specific tribunals, usually chaired by specialist sports lawyers rather than the ordinary courts. In the UK, sports resolutions sits at the apex of domestic bodies. But for many national and international sports governing bodies, they provide for appeals to CAS. CAS was founded in 1983 with a mission to supply a mechanism for sports-related disputes to be determined by experts. And during the course of this century, most major global sports and all Olympic sports have subscribed to its jurisdiction, motorsport being a significant exception. Last year, CAS ruled on no less than 900 cases. CAS's decisions can themselves be challenged before the Swiss Federal Tribunal on grounds equivalent to those that trigger a judicial review in this country. And when challenge is made in the High Court here to decisions of British sports governing bodies where there's no resort to CAS, judicial review type principles, if not judicial review procedures, similarly apply. But what the courts, either in Switzerland or in the Strand, will not do is to second guess the merits of the decisions of sports expert tribunals. That is without their spare of deemed competence. Now, the major object of sport-specific law is to ensure that there be, as far as possible, fair competition, by which I mean that sportsmen or women get to the actual or metaphorical start line with, again, as far as possible, equality of opportunity, so that the result of the contest, luck apart, depends on talent and commitment and not on some form of cheating. In a case called Ivy in 2018, the Supreme Court was concerned with a card game of chance, Punto Banco, played in a casino. And the issue was whether the player who profited by so-called edge sorting could retain his winnings, or whether he could be denied them because he had cheated. There was no conceivable definition. Could Punto Banco be called a sport? Lord Hughes, in his leading judgment, gave examples of cheating in sport, some of which, dare I say, were a little far-fetched, even for a Supreme Court justice. But one of which was paradigm, the taking of performance-enhancing drugs, which is the most pervasive problem in modern sport. There is all but universal consensus that the use of performance-enhancing drugs is unacceptable. And since the turn of this century, the World Anti-Doping Code, in its various versions, policed by the World Anti-Doping Authority, WADA for short, applies to almost all sports. It's WADA which decides what are prohibited substances, a somewhat movable feast. It's WADA who can prosecute and can be joined in proceedings brought by national doping authorities, NADOs, for breach of the code. And doping in some sports has spawned their own doping appeal tribunals, for example, mixed martial arts and Ironman, and indeed the European Golf Tour. That tribunal has never sat, presumably because the drug has not yet been invented, which could guarantee a hole in one. Now, essential to the World Anti-Doping Code is the strict liability rule in doping offences. Faced with a charge of an anti-doping rule violation for presence in his bodily fluids or use of a prohibited substance, it is no defence to an athlete to claim that he was the victim of mislabeling, contaminated stock, or faulty advice from anyone at all. In an early CAS award, the panel said this: it is the trust and reliance of clean athletes in their sports, and not the trust and reliance in their physicians and coaches, which merit the highest priority. At the starting line, a doped athlete remains a doped athlete, regardless of whether he or she has been victimized by their coach. In this instance, the interests of the many have to be preferred to the interests of the one. It is, I think, obvious that the result achieved by a doped athlete cannot stand, and for pragmatic reasons, the advantage is presumed without need for proof of any particular cause and effect. The degree of care taken to avoid the infringement does come into play, but only when deciding whether and for how long the athlete should be subject to a period of ineligibility. There, the major sanction of ineligibility for up to 4 years for a first offence can be mitigated where the athlete can show that he can prove no fault or no significant fault, concepts which are fact sensitive and take account of the age of the athlete, his degree of education in anti-doping, his experience. Presence is proved by positive tests in authorized laboratories of A and B samples of urine collected from the athlete. Use, where presence cannot be established by those means, is proved by any reliable means. Admissions, eyewitness accounts, the so-called biological passport, recently supplemented by a blood steroid test. These monitor selected biological variables over time to reveal the effects of doping. For example, the sudden elevation of blood cells before a major competition. Anti-doping rules, of course, have to be compatible with the general law, and they've generally resisted challenges that they fail that test. A striking instance is provided by the case Mekabadina and Madsen, long-distance swimmers whose explanation for the prohibited substance found in their samples was that they had eaten, on the night before their competition in Brazil, sarapatel, a local delicacy prepared from the testicles of wild boars. That's a sort of hors d'oeuvre favored by ex-minister Matt Hancock in the TV show, I'm a Celebrity, Get Me Out of Here. The European Court of Justice found that anti-doping rules were prima facie anti-competitive, but that they were justifiably so. The oddity of that case is that a CAS panel had already found, not only once, but twice, there was no evidence that either swimmer had ever eaten sarapatel at all. As a leading case, it is the Euro equivalent of Donoghue and Stevenson, which founded the more modern law of negligence on the assumed but unproven premise that the plaintiff drank ginger beer from the manufacturer's bottle, which contained a snail. Now, the anti-doping regime can only work if tests can be administered out of competition as well as in it. Michelle de Bruyne, Irish triple gold medalist at the Atlanta Olympics, was later tested at her home. Her urine was found to have contained Irish whiskey. Some may think that that was a waste of a good drink. But swimming's governing body charged her with manipulation. Her defense was that the sample she gave was clean, but someone must have contaminated it en route between her home, where the sample was taken, and the laboratory where it was tested. She had this difficulty. At the only overnight stop, the solitary living being, apart from the testers themselves against whom she sensibly made no accusation, was a dog. That was a problem that even her fluent Irish advocate could not solve. To fortify the out-of-competition testing regime is the whereabouts rule. Athletes subject to the regime have to provide details to their anti-doping organizations of precisely where they are at any time so as to be available for testing. That is a huge intrusion on privacy, but it is the price which is laid down to be paid for participation in their sport. The presumption is 3 strikes, 3 missed tests, and you're out. Christina Hurrigu, the British 400-meter track star, had missed her third test, but she was able to persuade a tribunal that she had a legitimate excuse, as a result of which she was free to compete in the Beijing Olympics in 2008, mercifully for this country, since she won Team GB's only track and field medal of the Games. Incidentally, both Michelle and Christine have become lawyers. There's a lesson there for you bar students in the audience, though what it is, I'm not quite sure. Now, cheating in sport is not, of course, confined to doping. It's multi-layered. It's often fueled by gambling. The follower of sport relishes its unpredictability, but for the gambler, predictability is all important. Not only players, but alas, officials have been tempted to distort a competition's result. At its most serious, cheating is coincident with criminal law and amounts to corruption. At another level, it can be a breach of the civil law, an express or implied term not to cheat. But yet another level, it falls foul not of the criminal or civil law at all, but only of the codes or rules of the game, and it becomes a regulatory offence. 3 Pakistani cricketers were persuaded in aid of a purported betting coup to bowl 3 no balls at particular junctures in a test match against England at Lord's in 2011, what is called in the parlance spot fixing. They were found guilty of a breach of the ethics code of the International Cricket Council, but later in the High Court also of conspiracy to cheat. Specific forms of sport-specific forms of cheating which give rise to disciplinary action can cover a multitude of sins. Selecting for a team in any sport persons who are ineligible, claiming non-existent or less serious disabilities to improve one's classification in Paralympic sports, consciously breaking the rules as to ballast in yacht or battery construction in motor racing. Some cases pose nice questions as to what is or ought to be prescribed. Take ball tampering in cricket as a useful illustration. So-called sandpapergate, where certain Australian bowlers wrongly altered the match ball's surface by application of sandpaper to increase its propensity to swing or turn, creates no problems. More nicely, there were 2 national captains, du Plessis of South Africa, Chandimal of Sri Lanka, who were punished for using saliva infused with sweets to shine the match ball, which the ICC and MCC, the cricket's legislators, had held was prohibited, even though some might say, with some force, that since shining with natural substances is permissible, there's no reason to prohibit shining with artificial substances. Where criminal and regulatory offences coincide, the public authorities have these advantages over sports governing bodies: no surveillance, no subpoenas or witness summonses, no access to bank accounts, all of which the state can deploy. The spot fixing and the Lord's test to which I referred was only proved through the taping of conversations with the players by an investigative journalist, the so-called fake sheikh, masquerading as a facilitator of a gambling coup. To compensate for this, the rule against self-incrimination does not apply in sports regulatory cases, and indeed several sports codes expressly provide that adverse inferences may be drawn from suspect silence. The penalties available to public and private bodies also differ in substance and in scale. No sports tribunal can impose a prison sentence, but equally no criminal court can impose a match ban. To their disadvantage, the Pakistani trio was subject to both. Now, in Sarnico and Roth-Schmidt Company, Lord Justice Strutton memorably said, "There must be no Alsatia in England where the King's writ does not run." In consequence, the court's procedures can be directly engaged when breaches of criminal or civil law are involved, off or on the field of play, but with due regard for the so-called specificity of sport, a phrase popularized by the European Commission. In Barnes, the Court of Appeal decided when it was and when it was not appropriate for criminal proceedings to be instituted after an injury is caused by one player to another player during a sporting event, here football. It held, in a sport in which bodily contact is a commonplace of the game, the players consent to such contact, even if through unfortunate accident, injury, perhaps of a serious nature, may result. However, such players do not consent to being deliberately punched or kicked, and such actions constitute an assault. Assault and battery are, of course, torts of intent. But what about a sport such as boxing, whose very purpose is to inflict bodily harm? In Brown, which was actually a case about sadomasochism and not sport, the House of Lords decided that there can generally be no defense of consent to actual bodily harm. But as to boxing, Lord Mustill, giving the leading speech, said, "It is, in my judgment, best to regard this as another special situation, which for the time being stands outside the ordinary law of violence because society chooses to tolerate it." Negligence, of course, is concerned with the infliction of injury where the tortfeasor had no intent, but his act or omission fell short of an appropriate objectively set standard. Now, since my function tonight is not to try to give you a lecture on tort law, but on sports law, I shall simply note that the shape of the duty and what amounts to its breach is conditioned by the sporting context as it is in the criminal sphere. And again, the classic notion of taking all reasonable care is what the Court of Appeal espoused in another football injury case. The level of care required of officials in control of a game is also special. It owes a duty, those officials, of care towards a player. See Smolden, a rugby union case. And because the officials function, the duty is a higher one than that which is owed by players to each other. And offences such as consent or contributing negligence have no role to play when the referee or other official is sued in tort. I move from tort to contract. Sam Goldwyn, the Hollywood producer, famously said, a verbal contract isn't worth the paper it's written on. And the most casual glances at the sports pages may suggest that certainly in the field of football, written contracts aren't worth that much more. But yet again, the specificity of sport affects the ordinary law which would otherwise apply. In normal industry, an employee whose contract has expired is usually free, subject to any justifiable restrictive covenants, to find new work with another employer. If Sainsbury's wish to employ a Tesco's manager without any inducement of breach of contract, it will not be expected to pay a transfer fee. If Sainsbury's employ a staff member trained at Tesco, it will not be expected to compensate Tesco for the education provided to that trainee. But in football, it's taken more than a century for the law to treat players as other than chattels to be brought and sold. Through leading cases, in England, the case of Eastham, relying on the common law requirement of justification and restraint of trade, and in Europe, Bosman, relying on the right of freedom of movement within the community. And the end product of this litigation here and abroad is the FIFA regulations on the status and transfer of players, which is an uneasy compromise between two irreconcilable objectives, contractual stability on the one hand and freedom of employment on the other. Under those regulations, a player can terminate a contract for not only just cause, but also for so-called sporting just cause, which is obviously an expressly sport-specific concept. That's not defined unhelpfully otherwise by the reference to the need to determine it on a case-by-case basis, taking into account the player's personal circumstances. Article 17 of those regulations provides for the consequence of termination without either of those two forms of cause. And it was applied by Cass in a case called Matusalem to adopt a test of the market value of the player as compensation to be paid by him or his new club for breach of contract with his old one. So you can see that the ghost of the player as chattel lingers on. I should also mention in this context financial fair play rules, which in broad terms impose at both European and domestic level on clubs a spending cap on wages, transfers and agents' fees up to a particular percentage of a club's total revenue. These rules have, as far as I know, no equivalent in other industries, but they are designed to achieve a level playing field and to increase fair competition between clubs, though critics say it does not have that effect. Turning from the common law to statute, sport also has its effect, notably in the anti-discrimination law contained in the Equality Act of 2010, which outlaws, subject to certain exceptions, indirect or direct discrimination against persons with protected characteristics. There are, of course, no sporting exceptions for the protected characteristic of race, though regrettably, race discrimination appears to be rife in sport. But there are sporting exceptions for disability, age, and gender and sex reassignment. Disability first. The definition of disability under the Act is that an individual has a physical or mental impairment that has a substantial and long-term adverse effect on the individual's ability to carry out normal day-to-day activities. It's self-evident that, save exceptionally, such impairment will affect the individual's capacity, but the escape hatch for employers of sportsmen and women, or those who provide sporting facilities, lies in the restricted definition of normal day-to-day activities, which government guidance suggests does not include playing sport, which is a somewhat dispiriting approach for those who consider that sport is or should be part of everyday life. Turning then to age, where the protected characteristic is age, A does not discriminate against B in circumstances within the scope of the Act if A can show A's treatment of B to be a proportionate means of achieving a legitimate aim. And that criterion is satisfied in sport, where the grouping of competitions by age, at one end the various categories of the young, at the other end the various categories of the older, more politely called masters, again enhances the fairness of the competition. Sex and gender reassignment. It is under the Act lawful to continue to organise separate sporting competitions for men and women where physical strength, stamina or physique are major factors in determining success or failure, and in which one sex is generally at a disadvantage in comparison with the other. And it also makes it lawful to restrict participation of transsexual people in such competitions if it's necessary to uphold fair competition or safe competition, but not otherwise. Now, the Act does not say in so many words that it is actually unlawful to allow trans women to participate in competitions earmarked for men. And should they be allowed to is a question which has sparked so much controversy. First, just a little history. Before this issue ever arose, there was an issue about not transsexual persons, but intersex persons, as they used to be called, hermaphrodites, sharing male and female sexual characteristics. And there was much litigation about these, finally brought by Caster Semenya, the well-known South African 800-meter runner, brought the validity of the regulations before the Euro Court of Human Rights in Strasbourg, having failed before CAS and the Swiss Federal Tribunal. By a bare majority of 4-3, a chamber of the court, not, I emphasize yet, the full court, ruled that the Swiss Federal Tribunal had not afforded Semenya, quote, sufficient institutional and procedural safeguards to allow her to have her complaints examined effectively. And therefore the court was, to quote again, unable to determine whether the differences of sexual development regulations, as they're called, as applied in her case, could be considered a measure that was objective and proportionate to the aim pursued of protecting fair competition for female athletes. So you can see it avoided pronouncing on whether the regulations could be justified. For the moment, the version recently approved by the World Athletics Council remains in place, but it is clear that the last chapter in this story has yet to be written. One might reasonably assume that rules vis-a-vis the participation of transsexuals in women's competition would be still more and certainly not less restrictive than those applicable to intersex persons. But the guidance from the International Committee, which is the body at the summit of world sporting governance, has changed over time, but has recently been ambiguous since it's asked global bodies to give equal consideration to the inclusion of athletes and fairness for women when drawing up eligibility criteria. And given the ambiguity of this sphere not coming down on one side or the other, there's no consistency in the choice made by international federations or their sports governing bodies. Some, like World Athletics, impose bans for trans athletes who've undergone any part of the process of puberty before transition. Some grant permission to compete if by hormonal treatment the testosterone level of the trans athletes has been lowered to specified figures. Some now create open competitions for all sex and gender identities, and competitions limited to trans athletes may yet, who know, arrive on the SBG's agenda. My own starting point is short on this. The majority of sports have always taken a binary view that there are women's events and there are men's events, and the defining factor has always been biological. Biological, indeed, has been the factor which creates different categories in all areas of sports. Multiple weight categories in boxing, two sorts of crews divided by weight in rowing, age categories in track and field and other sports. So it seems that to permit someone who identifies as a female, but whose male biology is unchanged, to compete in sports which are affected by biology would create an unprecedented exception to a hitherto well-established sports-wide principle. No amount of self-identification of someone born male, but who later post-puberty identifies as female can, according to experts in physiology, itself change that person's basic biology. And if the science still confirms that male biology gives an advantage in terms of sporting performance, it follows inexorably that sports governing bodies must respect that fact, if fact it be, in the interest of its guiding principle of fair competition here for women. Now, I'm conscious that this inevitably cuts across the concept that trans women are women for all purposes, hence the sometimes extreme vigor of the debate. Another burgeoning problem in sport is the change of nationality by athletes who wish to maximize their chances to compete at the highest level with the associated monetary awards, but whose path is blocked in their country of origin by the sheer number of talented athletes there. Take, as a classic example, distance runners in Ethiopia or in Kenya. So rules as to the circumstances permitting a change of so-called sporting nationality, as distinct from a change of civic nationality, have to be devised. And Cass epitomizes the dilemma succinctly, quote, it fully endorses the objective of preserving a link between national team competitions and national teams, and the avoidance of a situation in which national teams are substantially or wholly composed of sporting mercenaries acquiring belated nationalities of convenience. The American poet Grantland Wright wrote, for when the one great scorer comes to mark against your name, he writes not that you won or lost, but how you played the game. And the concept of the spirit of sport was much discussed after the third Ashes test this summer, where the English batter, or I would still prefer batsman, Johnny Bairstow, wrongly thinking an over had been concluded, left his crease to wander down the pitch and was promptly run out by the Australian wicketkeeper. Of course, the very concept of the spirit of sport distinguishes it from law. The preamble to the MCC laws makes the very point. Quote, cricket owes much of its appeal and enjoyment to the fact it should be played not only according to the laws, but also within the spirit of cricket. There is, of course, nothing to stop the spirit of cricket or of any sport being part of a legally binding code. And indeed, oddly, the International Cricket Council Code of Conduct for Players does precisely that. Or at least, if not embodied in that particular way, it could be deployed as an aid to interpretation of any open textured sporting rules. But I fear that the spirit of sport is more breached than observed, notably in football, the so-called professional foul, theatrical diving to win a penalty, running down the clock to prevent a late comeback by the currently losing team, and not just in football. A modern cricketing hero, such as Stuart Broad, has frequently chosen to ignore a referee's oversight when he knew that he was actually out according to the game's rules, relying on the technical truth that one can only be out when the referee says so. But we recall examples of fair play in sport precisely because they are so few. Adam Gilchrist, the Australian cricketer, is remembered not only for his achievement with bat and gloves, but for walking when he considered himself to be out, sometimes indeed contrary to the decision of the umpire. Fair play in sport may always be more an ideal than a reality. After all, W.G. Grace, the most famous of any English cricketers, was once clean bowled. He simply reset the stumps. And he said, these people, pointing to the spectators, have not come to see you bowl. They have come to see me bat. There are, however, I fear, more Broads than there are Gilchrists in the modern game, since money, reputation, career, and national pride meant that winning at almost all costs has firmly taken pride of place. On that sober note, I will end my lecture and expose myself to a barrage of questions, whether fast or spin. But I have one postscript, an advertisement from Liverpool's John Moores University for a degree course that says this: sports law is now a globally recognized legal discipline that regulates the dynamic and lucrative sports industry. Those of you at the start of your life in the law may care to think a little bit about that.
Thank you very much. Thank you, Michael, for a wonderful and wide-ranging lecture on so many topics. That must throw up all sorts of questions. Questions here in this theatre at the moment, or online from anyone? Can I just? Oh, there's one there. Yes. Take the microphone. Thank you.
Mr. Beloff.
Yes.
It is a more or less hypothetical question. It's a borderline of cheating. That is their issue that is bothering me for a long time. Hands of God by Maradona's goal in Wembley, between England and Argentina. Now, what will be the retrospective effect can be made on since we have invented VAR system in a modern form already. This one can be, do you think that it could be challenged?
Yes.
I don't disagree that he was the best player in the world. Yes. But this particular goal was concerned. It's still bothering me. That it is not a fair way of winning.
I certainly agree with you on. I'm certainly agree with you on your last observation. I'm slightly distressed to learn that you have borne that as a grievance for nearly 30 years. But be that as it may, you make a very fair point. Nowadays, with technology, it ought to be able to be rectified immediately when you've got this procedure for the video assistant referee, the video assistant referee. What happened, of course, in Spurs Liverpool was that the system wasn't properly engaged. But if after that there is still no agreement by the relevant official that the goal was achieved by cheating, that's where the field of play rule kicks in. And I just want to add one footnote. Those of you who follow rugby football may recollect that when one watches a match being televised and an issue arises as to whether or not a player has actually managed to ground the ball over the line, you can look at it from a variety of different angles and you won't necessarily get the same answer. The truth is that the camera cannot actually lie, but it can be economical with the truth. So that even if there are notional errors, it's not always the case that the camera, if properly deployed, could identify what they were.
Yes.
Yes,
Back there. Yes, thank you.
Do you think that the notion of cheating in sport is getting ever broader and perhaps too nebulous when the idea of sport is extending well beyond what goes on the pitch? For example, with the introduction of a whole host of financial fair play rules, the idea of cheating when it comes to Man City allegedly falsifying their accounts to Barcelona allegedly paying off the referees for a decade, very different levels of cheating. One relates to the game itself, one is quite far removed.
Yes, I mean, I agree. Partly because of time, my lecture really focused on what goes on in the field of play. But if I'd been asked to give a lecture on corruption in sport, I would have spent a good deal of time talking about the backroom deals that have gone on. I mean, give an example, which I think everyone now appreciates. There was something very suspicious about the fact that the World Football Cup was awarded in sequence on the same occasion to Russia and then to Qatar. And you have to ask yourself, how on earth did that occur? Well, I have had, as it were, some advantage inside information about what happened, not in that, but in the award of Qatar to host the World Athletics Championships in 2019. I don't know if you know Qatar, but it's not a place in which one would pleasantly run if one had the option of run in a more temperate clime. And I have heard it said, and indeed, alas, the president of World Athletics at that time, Lamine Diack, has since been not only held in breach of the World Athletics' own ethics code, but actually has been found guilty of various frauds by the French judiciary. So yes, there is, alas, a lot that goes on off the pitch as well as on. And I don't think that the example you chose is necessarily a bad example of an overreach by the law, because one can see that if you want to achieve as far as possible some degree of equality between the teams playing, say, in the Premier League, then you've got to have some kind of limit of the amount of money that otherwise, with their rich overseas owners, they could spend. So that's the explanation for it. As I say, I'm not certain how well it's worked, but there we are.
We've got a question now online, which is this: even with technology, we still see inconsistencies within sports, most notably in football. How do rules and law actually govern these inconsistencies? And are they capable of doing so in a consistent enough manner to be satisfactory?
Well, they obviously are not perfect. The addition of technology, the addition of an additional review by persons who are not, as it were, the officials or referees on the pitch, in both in cricket and in football and in cricket, is an advantage. As I say, the camera doesn't necessarily always give the full picture, but it's a step forward. If you ask me whether or not one can eliminate that, the answer is no, one can't. At the end of the day, it's human beings who are making the decision. And there's been a very interesting discussion in the national newspapers after the weekend and the Spurs-Liverpool match as to why it was that errors were made, whether the persons who were officiating had just been adjudicating in Saudi Arabia, were they affected by jet lag? Do we pay enough for referees and officials? All these issues have been raised, and we will seek, no doubt, in all sports to get as close as we can to a correct and just verdict. But if you ask me if we're ever going to succeed in eliminating error, the answer is no.
Another question from, yes. Can we have the microphone here, please?
Please may you share with us your favorite and best arbitration in sport story, if it's not too confidential. If possible, please.
Well, there you are. You see, someone has asked me to identify. I mean, obviously, the case of which I'm proudest and the one that I was most interested in was I represented Christina Hurregu when she was on this 3 strikes and you're out and would have been not eligible to compete in the Olympics. And the reason I remember it so well is that I was actually in the Bird's Nest Stadium when she won Team GB's only gold medal. And as you can imagine, I was sitting next to a range of other CAS arbitrators from a whole different jurisdictions. And I must have appeared to them to have gone completely berserk. I mean, you've seen people on the screen cheering and so on and so forth. I was hyper cheering. And as I say, that's the one that I think was the one that I would cherish most as an advocate. As an arbitrator, gosh, one has almost an endless supply of stories.
Yes, John.
You promised me that as an expert you weren't going to.
Michael, John Mercer, KC, thank you very much for your lecture. It's always fantastic to hear from you. My question is about privacy of sporting disputes. There is a movement towards having disciplinary procedures held in public. We know that with Strasbourg, we saw that in terms of the Yorkshire cricket matches. There is also let's say, a noise gathering towards the publication of awards in sporting arbitrations. What is your view about both?
Right. First of all, there's no doubt at all the direction that sport is traveling. After the so-called the Pechstein decision in the European Court of Human Rights, CAS itself has recognized that if there are disciplinary proceedings and the athlete wishes them to be held in public, he or she has the right to do so. I myself, in this conflict between preserving confidentiality on the one hand and open justice on the other, I happen to be an open justice man, as well as in other spheres of debate, I happen to be a free speech man. But I'm particularly interested that the awards of sporting arbitrators should be published. Not all CAS awards, for example, are published, and sitting as an arbitrator from time to time, one wishes that the advocates or the CAS counsel who assist one actually knew what the precedents were in the particular case one is deciding. And I also think it's a pity that not all those cases, the awards that are made, are in fact published, because it improves and creates a jurisprudence that even in a forum in which there's no precedent, one does want a certain amount of consistency. And I've been involved myself as an advocate, many years ago, in a case involving Fulham Football Club as to whether or not a previous award ought to be published and ought to be factored into the decision of the current tribunal, and the decision at the end was against it on the grounds that it had been, as it were, then a private hearing. But no, I think I both prophesy and I believe that the march ought to be in the direction of more open justice and maximization of the jurisprudence being made available to persons who are sports lawyers in whatever capacity.
I saw other at the back there.
Yes, yeah, I'm watching.
Hi, sorry, I just want to expand a little on some of your remarks around transgender athletes. I think we all, as lawyers, know that sometimes when there's technological, legal, social advances, the law sometimes reacts quite hastily or tries to change things in response. And sometimes that's the right decision, sometimes it's the wrong decision. One thing I want to ask is kind of get your view on whether you think some of the reactionary changes that have happened, particularly in the last kind of half decade regarding transgender athletes, serves to undermine a lot of the accomplishments women have made in advancing women's sports in the last particularly 50 years. So one example that's kind of been drawn to mind is the example of chess, which is obviously recognized by the IOC as a competitive sport. I'm not sure if there are any chess fans in the room, but there's a good few if there are. But obviously in August, the International Chess Federation banned transgender women from competing in their competitions. And to me, that kind of seems to be the logical extreme, that fundamentally there is an implication there that women, the implication of that decision is that women who are born women are less good at chess than women who are not born women. And that to me seems to undermine a lot of the accomplishments women's sport has made, particularly in the last half century. Yes. What are your thoughts on that as kind of reactionary rule change?
Interestingly enough, conscious as I was of the time limits on my lecture, I cut out a passage which referred exactly to that decision of FIDE, the International Chess Governing Body. And I note that what they have said is that they have suspended pro tem trans athletes from participating in chess competitions under their authority, quote, pending further analysis. And the question I ask is the question you've obviously asked yourself, but what do they think further analysis is going to prove? I mean, it's only relevant if the possible outcome is that women are somehow inherently less good at chess than men. I would be most disappointed, and indeed I would be surprised if that were the outcome. But you're right, the fact that the question is asked in a sport which is basically a mental sport rather than a physical sport does suggest that sometimes these matters can go too far. I mean, I was interested in another recent debate that we had about angling. Why are trans women barred now from angling? Well, apparently it's all to do with upper body strength and whether one can cast one's fly 80 meters or 50 meters. And someone said, well, surely the most equitable solution is to say there's a maximum on which you can cast your fly, and that which an able-bodied woman ought to be able to do. But there we are. I mean, there are these marginal questions. I'm afraid, though, in track and field and swimming and so on, I am adamantly in favour of the way that governing bodies are dealing with this, though I do realise the upset that it legitimately causes to other persons. And as I say, I had to express my view, irrespective of what reaction I might get. And I should say that on other occasions, and I've spoken on this topic, I've had a very hostile reaction, extending to saying, so-and-so, Mr. Beloff, should not have been allowed to speak to us at all. But I believe in freedom of speech. I believe in an informed debate. And as I say, I'm a lawyer. I follow here the physiology and the medics. If they're wrong, then the whole premise of what's being done is wrong. But at the moment, I'm only a layman in that way, and I assume that they've got right.
I saw another over here. Yes.
Yes. Which we. Hi.
Danielle, thank you. I note that you made the comment that you prefer the term batsman as opposed to batter. Is that a personal or a legal distinction while we're talking about sort of gender inclusivity in sport?
No, it's because I'm over 80 and I was brought up knowing that they were called batsmen, but I quite understand, in one sense, going towards, as it was, the huge advances that have been made in women's sport and their recognition over really the last 2 decades or so. It is phenomenal. I mean, you now read about women's football in the pages of the Times. When did that start? Can't have started more than 2 or 3 years ago. And in every way, I'm a great enthusiast for the maximization of women's sport. And if by using an old-fashioned term like that, I think I can be forgiven because it's not to be any hostility to women cricketers.
Thanks for such a great lecture. I'm big into horse racing, and with horse racing, 70% of the fixtures are owned by the racecourses, and the other 30% are as a racecourse, you bid the British Horse Racing Authority to buy them each year. And currently there's a kind of quite fierce argument going on between the racecourses and the regulatory authority, BHA, because the position is that the BHA would like to make it so that there are only 2 race meetings between 2 and 4 p.m. on a Saturday, and they would then force the racecourses to have their race meetings in the morning, currently not permitted, or in the evening. Now, if you're a racecourse like Chester, who depends with 11 of your 20 race meetings on a Saturday, on ladies from Merseyside coming in a Saturday afternoon, not on a Saturday morning or on a Sunday, then what I would like to know is what is the legal position of a regulatory authority enforcing these racecourses to have their race meetings at particular times, and some of these racecourses own these race meetings over 200 years. What it does not say on their paperwork regarding these race meetings is what time they are allowed to race and stage them at. All it says these race meetings will either be in the afternoon or in the evening when they bought them in the last 200 years.
Brief to council, I think.
Yes, I was going to say that I'm not here to give gratuitous and probably uneducated legal advice, but can I just make a couple of comments? It's a very interesting issue. I mean, first of all, I'm assuming that the reason behind this is to maximize the possibility of television coverage. I mentioned earlier that sometimes sports governing bodies have to adapt in order to maximize the way in which their sport is followed. The next point that I would make is that, in fact, if what you say is correct, that is to say there has been a wrong interpretation of their own rules, then, as I think the master reader has suggested, you go off and you challenge it in court, because that would be a justifiable way and a legitimate way of bringing those issues to the attention of persons who are competent to adjudicate upon it. My last point is that it's actually marvelous, isn't it, watching sometimes racing on television? How many of you watched the Arc de Triomphe yesterday from Blanchard? I mean, you realize that horses can do it, and sometimes exceptional horses do it very well, rather like exceptional advocates, I suppose.
Well, on which note, I cannot resist this question online. Double question. Do you feel fulfilled by your career? Has it been all you expected?
I think, well, it's been far more than I expected. And certainly, I mean, insofar as my career has diverged into sports law, it's been just phenomenal as far as I'm concerned. I mean, I've met all kinds of heroes of mine, from Roger Bannister through Seb Coe to Usain Bolt. I've been taken to, as I say, foreign parts, 5 Olympics, and I've lectured in double that figure overseas on sports law. And of course, I've enjoyed hugely watching these events. I mean, I'm just going to boast a little bit. I mean, I have been 3 times to the Rock Box at Wimbledon, twice, I should have said, because the then chief executive had been a former pupil of mine, but once, because I gave some advice to the Wimbledon. You know, they have this, they give all their players cars to take them from wherever they're residing to the courts. And the issue was whether or not it was a taxable benefit. And the advice that I gave was that it wasn't. That seemed to have been upheld. And as a result, we were able to go to Royal Box with some justification, not just being a sort of celebrity of some kind or a minor member of the royal family.
Just going to add to that another question from an anonymous attendee. What would you recommend, what advice would you give to someone interested in having a career at the bar specialising in sports law?
Right. Well, I always give actually the same answer. There are 2 bodies. There is the British Association of Sport and Law, of which I was once many moons ago the president, but that's a very good way of networking, getting to know people, attending their conferences and so on. And the other is a body called Sport in Law, which has been created by a very inventive person called Sean Cottrell. And that's another body that publishes things, it holds conferences, it has international and national moots. You join those 2 bodies and you'll get to know the people who count in the world of sport. Otherwise, if you've got time, and you may be able to do this coincident with your career, other career, because the courses are very frequently given online. There are many universities now. John Moores was just one of them, De Montfort is another, and so on, in which you can study sports law in the evening if you choose to do that, rather than watching television or whatever other activities you prefer getting up to of an evening. So that would be a way of doing it as well.
Thank you. Can we take 1 or 2 more? Yeah, in the back. Are we right? For a little longer? Yeah. We'll take 2 more questions, yes.
There's a tension between justice and some of the qualities of sport. So part of the attraction and entertainment of sport is the drama, and part of that is sometimes injustice. So you see this debate in VAR, for example, where some people say, well, perhaps it gives the just outcome, but the whole process removes some of the drama and the entertainment of sport. So do you think there is a tension between justice and the quality of sport?
Yeah, I mean, you are quite right that the introduction of something like VAR does delay matters. You want matches football matches, for example, to go on as far as you can uninterrupted by these pauses. It's rather like if you're an advocate, you don't actually want to be interrupted apart occasionally from an intelligent question by an intelligent judge, such as Master Reader or others, even more distinguished, if I dare say so, in the audience. But you do have a time break because of this. And one of the reasons, as I say, that the field of play rule is important is because you simply cannot tolerate the notion of bewigged and begowned barristers suddenly coming down in the middle and saying, you got that one wrong, and I'm going to apply for an interim injunction. I mean, I can tell you that the Court of Arbitration for Sport, when it first had its ad hoc panel at the Atlanta Olympics, tried to, as it were, sew up the possibility of anyone seeking to get some relief, interlocutory relief, in a local court by an inexpert judge by saying, we are here, we are CAS, we are the expert, recognize us. And I don't think I'm betraying very much of a secret, if I may just end on this. When we held the Olympics in London 2012, I was not part, because I was in fact a Brit, of the Olympic arbitral body then, but I was appointed, as it were, kind of liaison officer between CAS and the English organizers. And I went to see, with a couple of persons who were actually in charge of the CAS arbitral panel, to Igor Judge, who was then Lord Chief Justice, and we explained that CAS was there, what they did, why they were able to operate. And of course he said, well, I can't prevent an English High Court judge, if someone makes an application to him or her, giving some relief if they think it appropriate. But if the judiciary are told that there is this expert body in town and they've got a very full list anyhow, they will not be at all displeased if it was taken out. And you can see Master Reader recognizing exactly the virtue of it. So no one ever went off to court here, and there were several cases before the CAS.
Just take one more, then yes, in the middle here. Thank you.
Thank you, Mr. Beloff, for your insightful and entertaining talk. A question about motorsport. You mentioned that motorsport was a notable exception, and I wonder if you might speak a bit about that. Or some of the debates with motorsport and law quite topical at the moment.
Yes. Perhaps again, since you prompt me, I have to disclose. I was initially a so-called steward of the Royal Automobile Club, and the stewards were there to adjudicate upon issues that arose in motorsport. Mainly, I discovered that what was anticipated was the possibility of disputes about go-karting, a sport, an aspect of the sport of which I was wholly unfamiliar. In 10 years, we had one case only. I was then migrated to the international body, which sits in Paris, and we have a meeting once a year there. And in that period, there was only one case, and it was entirely about whether the sprocket should have been here or there, way outside my comfort zone. I was only there to say whether the procedure was fair or not. But the fact of the matter is that motorsport, for historic reasons, has chosen to maintain its own international tribunal based in Paris, and it's entitled to do that. And the other sports, perhaps I should have mentioned, were American specific sports, American baseball, American football, and so on. There one has, as it were, the exceptionalism of American sports. They are also outside the CAS jurisdiction. But in motorsport, of course, you're right. I mean, some really interesting issues can arise. You may have seen in the papers that someone, and now as a member of my chambers, is trying to overturn the result of the Grand Prix circuit of 2008. I'm not going to comment on whether I think he's going to succeed or not. But there it is. I mean, there are occasional issues, and there was, of course, a very fraught issue a couple of seasons ago, was there not, when something happened on the last lap of some Grand Prix, which prevented Lewis Hamilton winning his 8th title. I mean, unfortunately, they never happened when I was on that particular body. So be it.
You must treasure.
I'll just take it. Well, Michael, thank you so much for an illuminating lecture. You did make the mistake of mentioning W.G. Grace, so it allows me, therefore, to compare you with W.G. Grace in 2 respects, but not in the third. The third is, of course, about cheating. There's nothing you have said today which in any way either condones cheating or was in any way cheating yourself. However, it's probably fair to say that your legal career has spanned at least the length of time that WG's cricketing career spanned. And the second way in which you compare with him is that the audience have certainly come here to see you and not anybody else, and have learned a great deal from that. So thank you very much. Just one other thing, if I may. We have 2 Michaels at the front here. We don't have 2 Ronnies, but 2 Michaels. And I'd like to thank Michael, Master Reader, for such an excellent choice of lecturer as he has done in this series so far. So thank you to both of you.
Well, can I?
And just finally, if those in the room rather than those online, if you have a burning question to ask that you weren't able because of the chairman failed to spot you, you will, I think, have an opportunity to approach our learned speaker outside over a glass of something or the other. So thank you very much.
Can I just say it's a huge pleasure being a migrant from Gray's Inn to be able to address an Inner Temple audience. As always, I can tell you 2 things. Those of you who go on to career having to give talks, you always have more to say than you believe you have, and you always feel that I'm not going to actually be able to fill the time. But this time I managed to amputate a few of the paragraphs and so on, and I really was gratified by the intelligence and perspicacity of the questions that I was asked. I think anyone who lectures or speaks to an audience such as this really says it's been a marvelous evening if the questions have been of the quality that your questions have been. So thank you very much, and thank you for our prospective hospitality as well.